Hello, and a warm, spooky welcome to the EDRM Global Webinar channel. My name is Mary Mack. I'm the CEO and Chief Legal Technologist for EDRM, and today's webinar is an EDRM collaboration with our trusted partner, eDiscovery Today. It's called Important eDiscovery Case Law Decisions for October 2024. Our faculty experts are Doug Austin, Tom O'Connor, and the Honorable Judge Andrew Peck. We welcome your questions and feedback in the console. Questions will be answered both during and at the end of the webinar. And this webinar will be available for replay at your convenience for the next quarter, as all our EDR webinars are. Slides will be available after the webinar. And Kaylee Wallstead, EDRM's Chief Strategy Officer, is here. Can you please tell us what resources are available, Kaylee?
Absolutely, and I look forward to this fantastic monthly series that's been ongoing for over 4 years. So get ready for some spine-chilling case law upcoming. We're also loving On 24 with so many more ways for you, our audience, to engage. If you check out your console to the right of your screen, you'll see the question mark icon. If you click that, this is where you can type in your questions for today's faculty, and we highly encourage you to. As Mary said, slides will be made available after the webinar has concluded, and you'll notice the paperclip icon. That's for related content and resources. If you click on that, you'll see today's resources carefully curated just for you. First, the On24 engagement tools description for you to download to help you better engage with the platform. There's also a link to subscribe to eDiscovery Today's blog and never miss a thing. It's my favorite way to start the day. There's also a link to learn more about the Honorable Judge Peck and how you can engage with him. And then be sure to order your copy of Tom O'Connor's spicy newish book, eDiscovery for the Rest of Us, recently updated in collaboration with EDRM's trusted partner, NextPoint. And save your seat for next month's Case Law Edition. On November 21st, there's a link to register. And up next on EDRM's Global Webinar channel, November 12th at noon Eastern, EDRM has a Q4 workshop on balancing ethics and efficiency with Gen AI and legal. There's a link to register for that event, and we hope you will join us. Be sure to share your much-needed insights on eDiscovery Today's annual 2025 eDiscovery Today State of the Industry Survey. Doug puts this out every year. He gets great responses, and the information and analysis is outstanding, and EDRM is proud to once again be a sponsor. Speaker bios can be clicked and popped up to learn more about today's faculty. And then our favorite thing, just like Zoom, you'll see a smiley face emoji in your console. And if you click on it, there's many more reactions for you to share during the webinar. And we highly encourage you to engage with them. We're having a lot of fun with them on this platform. And if you click the Twitter bird, you can follow EDRM and eDiscovery Today on LinkedIn. And back to you, Mary.
Thanks, Kaylee. And our faculty, we have, of course, Doug Austin. Doug is the founder and editor of EDRM trusted partner eDiscovery Today. He is an established eDiscovery thought leader with over 30 years of experience providing eDiscovery best practices, legal technology consulting, and technical project management services to numerous commercial and governmental clients. Doug has published a daily blog since 2010 and has earned J.D. Super Awards 3 times. Tom O'Connor is the director of the Gulf Coast Legal Technology Center and a nationally known consultant, speaker, and writer in the area of computerized litigation support systems. Tom's consulting experience is primarily in complex litigation matters where he's worked with firms of all sizes, and most recently the plaintiffs in the BP litigation. He has also been appointed as a technical consultant by various federal and state courts on cases dealing with large amounts of electronic evidence. And as Kaylee said, his most recent edition of his popular spicy book, eDiscovery for the Rest of Us, was launched at Legal Week with EDRM's trusted partner, NextPoint. The Honorable Judge Andrew Peck is a Band 1 Chambers ranked senior counsel at DLA Piper, where he advises on copyright and trademark matters and also serves as a resource for the firm and its clients on litigation strategy and discovery issues. He brings the judge's perspective there. Judge Peck retired as a United States Magistrate Judge in the Southern District of New York after serving for 23 years, writing many of our first and most significant eDiscovery opinions. And EDRM is grateful to all three gentlemen for their service on the EDRM Global Advisory Council. And without further ado, Doug, do we have some cases on this scary, scary day?
We do indeed, Mary, and thanks everybody. Welcome to our October 2024 case law webinar on the EDRM network with eDiscovery best practices takes that are so good it's scary. We do indeed have another 6 unique cases to discuss this month, and those cases address disputes related to relevance of hyperlinked files, sanctions for failure to preserve text messages, use of technology-assisted review, requirements to produce metadata in discovery, number of custodians in discovery, and self-collection and discovery on discovery. Don't be afraid to ask questions. We do welcome them, and we'll try to get to as many as we can. And fear not, we'll send a copy of the slides out after the presentation, so look for that too. Of course, any ideas expressed by us here today are our own, not those of our organizations, clients, or partners. Disclaimers are like Michael Myers. You just can't get rid of them. And before we get started with these cases, here's a quick note about the webinar format and sources of cases. This is the latest in a series of monthly webinars about case law, and the cases we discuss each month will be those covered on eDiscovery today. We provide links to each of the stories about the cases, which in turn have a link to the actual case ruling, where you can check out the full ruling itself. These case law rulings are available courtesy of Kelly Twigger's eDiscovery Assistant site, which is a great resource not only for case law, but also for federal and state rules, checklists and forms, and a glossary of legal and eDiscovery terms. eDiscovery Assistant has nearly 39,000 lifetime federal and state case law rulings, and they add as many as several hundred cases a month. eDiscovery Assistant is the definitive source for eDiscovery case law out there. So with that said, let's get into the cases in our first treat, a case with bigger print. So why does it have bigger print? It's because the entire case law ruling is on the slide here, and it's a hyperlinked files case to boot. Here, California Magistrate Judge Sally Kim set the stage for the dispute by stating, the parties dispute whether Meta should produce documents that are identified as hyperlinks and documents that Meta already produced in response to plaintiff's request for production of documents. Plaintiffs argues that the hyperlinks to other documents and responsive documents are akin to attachments to emails that a party must produce. Meta responds that the hyperlinked documents are different from attachments to emails because searching for hyperlinked documents and reviewing them requires time and effort that is not required for producing an attachment to an email. Plaintiff argues that by the title of the documents alone, it is obvious that the hyperlinked documents are relevant and responsive to its request. Meta argues that it has reviewed the specific document cited in plaintiff's request and determined that the documents are not relevant or privileged. In denying the plaintiff's request to compel production of hyperlinked documents, Judge Kim stated, here the court agrees that hyperlinked documents are not the same as attachments to emails. Rather, the effort required to search for them is substantially greater than the effort required to produce attachments to emails. But here, Meta has reviewed the specific hyperlinked documents and assessed them for relevance and privilege, so the general burden is not an issue in this specific dispute. Plaintiffs argue that the documents are relevant and seek the court's assistance in requiring Meta to produce them. Courts rarely get involved in assessing specific documents for relevance, but rather make general orders about categories of documents that a party must produce. Courts in general rely on parties to assess relevance, and the system of discovery is based on trust that a party produces documents after review and assessment for relevance and responsiveness. Here, it is possible that plaintiff is correct and that Meta is required to produce the documents, but the only way the court can assess plaintiff's theory is to review each of the documents in question. The court cannot engage in that practice. So, Tom, the court stated that Meta reviewed the specific hyperlinked documents, so the general burden is not an issue in the dispute. If they can review the hyperlinked documents, what's stopping other parties for reviewing them as well?
Well, you mean other than the fact that they didn't produce them and the court won't make them?
Well, that's yeah.
I think those are barriers to review.
Those are barriers.
Yeah. Well, no, obviously, I mean, really, the first thing I thought of when I'm reading this, and I looked at some of the other pleadings in the case, is has the arguments, and thank goodness the court didn't go into the whole issue of hyperlinks, but has that issue become like the new boilerplate language? I mean, the defendants said several times, well, it's too difficult. It's too hard. It's too hard for us. I can't do this. It's too hard. It takes too long. It's too lengthy. It's not proportional. Then they turn around and say, but we did it anyways, and they're not relevant and they're probably privileged. So basically they're making every possible argument they can against producing the documents. I think that what it revolved around was, and the other thing, I couldn't find, the reason I looked at some of the other pleadings was I couldn't find how many documents we're talking about here.
Right.
It would have been interesting if they could have delineated how many were privileged, leave those out of the discussion, how many are left that they're not saying relevant. But the thing I focused in on was the fact that the court said the plaintiffs argued that by the title of the document alone, it's obvious that they're relevant. That's just not enough. You got to bring something to the table there, some sort of proof, showing of proof that these people were essential. This subject matter was key to the argument. You can't just say, oh, judge, look it. You can tell from the title that they're there because the judge, as the judge made clear, is not going to want to undertake, as the court said, the court cannot engage in that practice. So could they look at them? Apparently it wasn't all that difficult. Meta did it. So, but I think they needed more of a showing than just, oh, it's clear from the title or the subject matter, subject matter referring to the title of the document that it's relevant. You gotta come to the table with a little more than that.
Yeah, agreed. And that's a good lead into my question for Judge Peck, since they argued that the title made it clear the hyperlinked documents were relevant, responsive, but Judge Kim refused to review those documents to confirm that. If you were the judge, what, if anything, would the plaintiffs have needed to do to convince you to review the documents?
Going back to what you were talking about with Tom, I assumed that there weren't that many documents in this category, but maybe not. And, whether because of the larger number of documents or just creating an unofficial precedent for future cases, the court didn't want to go down the slippery slope. So, I would say they could have said, let's do a very small sample. We'll give you, Judge, half a dozen documents, 10 documents, and look at those. And if those do turn out to be relevant, then that should apply to all the others. If they're not relevant, we'll give up, something like that. Alternatively, through deposition testimony, through, what is, which of these emails with the attachment where they don't have the hyperlink were really crucial, were they responded to in certain ways that give you more information about the hyperlinked document, things like that. I mean, frankly, if I were on the bench, I probably would have said I'd look at half a dozen of them as a sample. But, similarly, I did that with disputes over privileged documents, and I've been seeing, and we've covered a lot of them, more and more decisions lately by judges who are offered to review the challenged privileged documents, saying, no thanks, not going to do it.
Yeah, no, I definitely understand. So definitely some great insights into that. Somebody commented that the plaintiff believed that Meta was withholding 141 requested documents. So not a tiny number by any means, not a huge number either, but certainly good information. Thanks for sharing that.
In a case involving Meta, I would say that's a very small number.
Sure. Yeah, I would think so too. Yeah, no doubt about that. But at least now it gives us some frame of reference. So thanks for that. So Mary, we've seen several courts now declare that hyperlinked documents are not the same as attachments. Is the issue decided for good? Mary, you may be muted.
I am indeed. Thank you. Well, I think it's obvious that hyperlinked documents are different from documents that are contained within or electronically attached to an email or text. So you can see that my position's shifted slightly on this issue. But the reason it had to shift is when I first heard about this, I was absolutely shocked at the idea that it was technically impossible to do, because in a Bet the Company case, even before 2006, when the rules changed, we were able to do that versioning with Documentum, because a similar situation applies to those kind of archival systems that function as collaboration platforms. So I think it may be technologically impossible now. I do believe that those who are serving the regulated industry market, like financials, trading, and things that have regulatory obligations, will drive the technological development in this area, because I don't think that the regulators will cotton too much to the technologically impossible thing. But there are things to figure out in terms of families and how you represent those in a review set. So no, I don't think it's settled up, Doug.
Yeah,
and
no,
I think whatever it may or may not be settled in terms of case law, things are going to change when our friends at Microsoft and Google change what their products allow you to do or not. And that's probably the ultimate solution.
Yes, I couldn't agree more. I would say that's music to my ears, but the real music to my ears is not hearing music in my ears. So I'll take that. There we go. So maybe it's the ghost in the machine, but we will move on to our next case. And by the way, shameless plug warning, Kaylee mentioned the State of the Industry Report survey. One of the new questions on the survey this year is, should hyperlink files be considered modern attachments? So certainly encourage you to fill out the survey, which will get you a free copy of the report when it's published in January. Now on to our next case, and spoliation cases are the quintessential trick and treat cases of case law. A trick by the spoliator turns into a treat if the other side is able to obtain sanctions due to the spoliation. So here, the defendant sent an email to the recruiter at his new employer, Caliber, 10 days after he started working there, identifying techs that I have worked with and all would make a great addition to the team. The plaintiff caught wind of the defendant's activities and sent the defendant a cease and desist letter, which the defendant forwarded to Caliber within days. Less than a month later, September 13, 2021, the plaintiff filed suit. He notified Caliber, who referred him to Counsel. Counsel advised the defendant orally of his obligation to retain and not destroy, delete, or throw away any documents, records, or communications that dealt with the allegations in the lawsuit. The defendant received his first written litigation hold from Caliber in November 2021. Guess what? during a conference with his counsel to review discovery responses, the defendant, quote, learned that his personal phone was set to auto-delete text messages after 30 days, unquote. So he did not preserve any text messages sent or received before January 4th, 2022. The plaintiff asked the court to find that Lockridge spoliated evidence, impose an adverse inference sanction, and award costs and expenses. Ohio District Judge Sarah D. Morrison stated, Lockridge was put on notice of potential litigation when he received the August 27 letter. Where a letter openly threatens litigation, then the recipient is on notice that litigation is reasonably foreseeable and the duty to preserve evidence relevant to that dispute is triggered. Judge Morrison also rejected the defendant's argument that the letter should not impose a duty on him to preserve evidence because he is a layperson. And she also rejected the defendant's contention that he did not know his phone automatically deleted text messages after 30 days and the loss was an honest mistake, stating, Lockridge is an experienced businessman. He is now the general manager for Caliber in Phoenix, and he previously served as an operations manager and store manager for Safelite. His plea of ignorance strains credulity. It is not plausible that a modern professional smartphone user like Lockridge could carry on for 4 years without realizing that his text messages disappeared after 30 days. She even called out defendant's counsel for their oral advice to retain evidence, stating that advisement was inadequate. First, an oral litigation hold is insufficient to reasonably protect against the spoliation of evidence. Further, a litigation hold, whether verbal or written, that fails to instruct a party to disable auto-deletion functions is not much of a litigation hold. Finding negligence and prejudice due to the spoliation, Judge Morrison issued a sanction stating, pursuant to Rule 37E1, the parties will be permitted to present admissible evidence of Lockridge's duty to reserve his text messages and negligent failure to do so, and argument on whatever inference the jury should take from that evidence. She also awarded attorney's fees and costs. So Judge Peck, many people think of adverse inference sanctions as a Rule 37E2 sanction, but Judge Morrison allowed Safelite to present evidence as to Lockridge's negligent spoliation of text messages and argue on whatever inference the jury should take from that evidence. Isn't that the same as a permissive adverse inference sanction?
It is not the same, although it's very similar. As I read this decision, the court was not going to give any instruction to the jury. That's what makes it different than a true adverse inference instruction under 37E2. Allowing counsel to argue it as a factual inference is similar, but doesn't have the same weight as it would when a judge says, you know, you're going to hear evidence that Lockridge didn't preserve his emails, blah, blah, blah. You may or may not infer from that that it was adverse to him. You know, what the judge says has much more weight with a jury than what lawyers argue, for good reason.
Sure. No,
it's similar, and it comes close to blurring the line between 37E1 and 37E2, but it is on the correct side of that line.
No, that's a great point. So, Mary, what do you think of Lockridge's argument that he didn't know his phone automatically deleted text messages after 30 days and that the preservation letter shouldn't impose a duty on him to preserve evidence because he's a layperson?
Well, I think all lay people should not have to have preservation. No, I'm kidding. I'm kidding. But well, I think it would be more credible that he didn't know he could adjust settings to save his text messages. I don't know that that's intuitively obvious to people. It's certainly obvious that you don't have a huge long string of text messages, but I mean, I don't think that everybody thinks about auto deletes and how to adjust them without explicit instruction, and that was a failure on the part of counsel with their oral preservation notice.
Yeah, true. Although I think, well, I know at least for iPhones, I don't know about Androids. I think the default is indefinite preservation. So you normally have to make a decision to change that. So makes you wonder, what the situation was there, but certainly dubious to say the least. So Tom, what do you think of Judge Morrison's calling out Lockridge's counsel's handling of the litigation hold? Does Lockridge have a potential malpractice claim against his counsel?
Well, I don't know. I mean, the judge was pretty clear, as already been pointed out. The judge said, "quote An oral litigation hold is insufficient to reasonably protect against spoliation," and I like a litigation hold, whether verbal or written, that fails to instruct about auto deletion is not much of a litigation hold. So certainly failings on the part there of counsel, but the judge really went to great lengths to discuss the experience of Lockridge. He's an experienced businessman. His plea of ignorance about the smartphone strains credulity. I'm not sure what the standard would be there between the knowledge of the counsel and the knowledge of the client regarding malpractice, but it seems like there was plenty of blame to go around on all sides here.
Yeah, there certainly was, and it definitely was a certainly an illustration of what not to do when it comes to preserving evidence in discovery, and obviously text messages we're seeing more and more being one of those forms of ESI that tends to be spoliated. So here's our latest case, and we'll have one more before we're done. So on to the next case. Which is was a putative class action suggested by Judge Peck. The dispute began as a search terms dispute, where the defendant stated that the plaintiff's proposed search criteria, which would require the review of 125,000 documents, was burdensome and disproportionate to the needs of the case. As Vice Chancellor Lori Will stated, the search terms alone support their argument. They include unlimited terms like D, Velodyne, and GraphCQ.com. But the defendant's counterproposal went too far. It eliminated terms relating to important issues such as Velodyne's products and Graph Industrial Founders shares, and it applied extensive proximity limiters to other terms. To address the issue, the defendants offered a treat and proposed to use a technology-assisted review process, agreeing to review the universe of documents captured by the plaintiff's broad search terms, so long as they were able to employ a TAR protocol. But the plaintiff, treating it as a trick, rejected the offer and insisted that the defendants conduct a manual review instead. Regarding defendants' proposal to use TAR, Vice Chancellor Will stated, TAR promotes efficiency in the discovery process in several meaningful ways, which she cited, including reduced document sets set for human review, a more uniform relevant standard than manual document review, and lower costs for litigants. She also said that TAR can also yield superior results. The plaintiff fears that TAR has the potential to exclude responsive documents from the review process, but this is a risk in any document review, including by human reviewers. Statistics clearly show that computerized searches are at least as accurate, if not more so, than manual review. Whether to employ it is a matter for the producing party to decide, since it is best situated to evaluate the procedures, methodologies, and technologies appropriate for producing its own electronically stored information. It is not up to the requesting party to block TAR if the producing party prefers it, nor is it necessarily a matter for the court to dictate. Where a producing party wants to utilize TAR for document review, courts will permit it. In stating all that, she managed to...
Sorry, Doug. Where is that wonderful quote from? Besides,
I was just about to get to that. I'm not just that quote, but in stating all that, she managed to cite the hat trick of Judge Peck cases to Silvermore, Rio Tinto, and Hiles. So I think she covered the gamut there for you, Judge Peck. So yes, wise words indeed. And it's not surprising that she ruled for the defendants, stating Thus, the defendants may use TAR to reduce their discovery burden so long as they're transparent with the plaintiff about their computer-assisted review process. Delaware counsel must remain closely involved in the review and sampling process for the TAR review. If the plaintiff believes that the defendant's response is deficient, it may seek relief from this court. So, Mary, unlike the Edgar case we covered last month, where the court ruled that the defendant must make a good faith attempt to use search terms before using TAR in that case, Vice Chancellor Will, in this case, sided with the defendant's proposal to use TAR. So what, if anything, do you think is different about these two cases that caused the rulings to be different?
Well, I think one, it's Delaware, which is traditionally business friendly. And then I think the most important thing is clearly this judge has positive experience with TAR and is a very sympathetic jurist and reads the opinions of our lovely Honorable Judge Peck. So I think that's a difference. Also, when you include a search term that's like grafcq.com, so like everything from that particular domain, I mean, the search terms were just so overbroad, and they couldn't get to an agreement there. So I think the judge gave great deference to the Sedona Principle 6, and I think that's what made the difference.
Yeah, absolutely. Yeah, it makes you wonder if the plaintiffs had started out with more reasonably scoped search terms, if TAR would have ever come up. But, no, we'll never know. So, Tom, do you think it's more likely that the plaintiff objected to the use of TAR because they were concerned about how accurate it was, or that they objected because they wanted to make it more difficult for the defendants to respond to the discovery requests?
Well, honestly, I don't know if I can figure out why somebody would insist that a party use manual review over TAR or even keyword search. I mean, that insistence in saying that that's going to be the most accurate way to find something seems to just fly in the face of everything we know, and as Judge Peck has pointed out numerous times, and as the court here reiterates, TAR promotes efficiency in the discovery process. So I'm not sure what they were doing, unless it was, the thought I had was, that last paragraph you have there, the defendants can use TAR so long as they are transparent with the plaintiff about the computer-assisted review process. Maybe the plaintiffs didn't know enough to be able to QC it in a meaningful way. If they were so hung up on manual review, maybe that's all they knew. And they were afraid that they couldn't do a meaningful assessment of TAR. I mean, we're only talking 125,000 documents here. I don't know that, they were going to slow down the other side in any meaningful way. It just seems like a head scratcher to me. But yeah, I kind of thought maybe they just didn't have enough experience to feel that they could comfortably or even accurately assess what was going on. But certainly what they were saying wasn't going to cut it. Didn't cut it.
They were obviously relying on the principle that manual review is the gold standard of documents.
The gold standard. Yes.
Right.
Where have I heard that?
Yeah, exactly.
That's all I can think of, is that's what they were familiar with. That's all they ever used. They didn't have not just TAR experience, but computer experience. And so they were trying to throw up an obstacle.
Yeah, well,
if they had done a little research on this subject, I think they would have come across Judge Peck's well-known decisions and maybe not wasted the court's time with that argument.
Maybe, perhaps. Certainly, it's certainly not unprecedented for an attorney not to understand technology, and we'll get to a case here in a bit that gets into that. But I do find it interesting that 2 months in a row now we've had a TAR case where the other side objected not to say, well, TAR should be conducted a certain way or with certain levels of transparency, but just objecting to it at all, which makes me wonder, if this is a tactic You know, I guess we'll never know, but it certainly does give you pause for sure.
Not one that's going to have any legs, that's for sure.
Right. So speaking of transparency, Judge Peck, Vice Chancellor Will stated that defendants could use TAR as long as they were transparent with the plaintiff about the process, but she didn't define what's considered to be transparent. Would you have set some transparency guidelines in place if you were the judge?
You know, it depends in part as to whether the parties briefed what they wanted to do or what they didn't want to do on transparency. Just throwing it to the court to come up with it, even a judge who seems knowledgeable about TAR, is not fair to the court and, you know, probably not the right way to go about it. So, you know, perhaps the judge, the vice chancellor, could have said, you know, and by transparent, I mean, you have to say what tool you're using, you know, is it a TAR 1 or a TAR 2 tool, and what's your validation going to be? But, you know, with a plaintiff who perhaps we are believing didn't understand TAR at all, you know, why would the court do all of that when it may not have been something that the plaintiff wanted, let alone what the defendant was willing to do? You know, I do want to point out one other thing. I mean, since I've been at DLA, I've been involved in a few cases that are in either Delaware Chancery or federal court in Delaware. And, you know, it goes back to the last paragraph on the slide. Delaware is one of those districts that really believes its members of the bar are the ones that can be trusted or relied upon. And it is often the case that you must, you know, whatever the rule may say about other lawyers having pro hoc vice appearance or whatever, it is the Maryland lawyers who, the Delaware lawyers who the courts look to in Delaware. And so by saying here, you know, I'm expecting the local lawyers on both sides to be involved, that's sort of sending a message to go work out the transparency and do it using, you know, the knowledgeable local lawyers, not their crazy New York lead counsel or whatever the situation may have been.
Yeah, that's interesting. I hadn't thought of that, but yeah, that's a great point. So yeah, very interesting case. Unpublished, by the way, but still very interesting. Here's our next case, also suggested by Judge Peck, where the parties submitted a joint Rule 26F report at the outset of discovery that discussed, among other things, how they would produce ESI. Parties' joint report also stated that when a party produced ESI into a format, the production would also include metadata and searchable extracted text. But the parties never discussed the scope of metadata that they needed to include, which of course led to a dispute after defendants issued a production into format with a handful of documents in native format, along with a load file containing searchable extracted text and 13 metadata fields, which the plaintiff called completely unusable. After the parties' attempts to resolve their dispute failed, the plaintiff filed her motion to compel. The court eventually held a hearing on her motion where plaintiff's counsel could not articulate how the search process worked, could not explain which metadata fields would be most helpful, and eventually admitted that she has not personally used the ESI platform into which the documents were loaded. So in considering the plaintiff's claims, North Carolina Magistrate Judge Robert Numbers stated, Baugh first claimed that the production was completely unusable as produced, but the statement is false. Baugh's vendor could access the ESI Handy Hugos produced, and it appears that she can review the materials included in the production and conduct text-based searches. He also rejected the contention that the production lacks base numbers and the necessary metadata, known as parent-child fields, to determine whether one file was included as an attachment to another, and also stated the court's efforts to delve further into the functionality of the eDiscovery platform chosen by Boss Counsel was frustrated by her counsel's lack of knowledge about how that system works. During the hearing, Boss Counsel admitted that she has not used the system, and she contradicted her vendor's claims about the production searchability. In denying the plaintiff's motion, Judge Numbers stated, Baugh's arguments are unpersuasive. To begin with, neither Rule 34 nor the joint report require production in native format. Instead, the parties agreed to produce most ESI in non-native format. And Baugh has not shown that she's entitled to all metadata fields available to handy Hugos. The joint report is ambiguous about what metadata each party must provide. Given the lack of certainty on that issue, the court will apply Rule 34's requirement that a party must produce non-native ESI in a reasonably usable form. Courts regularly find that producing ESI in a text searchable format qualifies as being reasonably usable. Baugh has not persuaded the court that the circumstances of this case justify departing from that practice. The court thus denies the motion to compel, and as a result, it will also deny Baugh's request for a protective order and a request for sanctions. So to Baugh's request, the court said, humbug. So Tom, what do you think about the admission by Baugh's counsel that she had not used the eDiscovery platform chosen by her firm?
Well, to answer a question you asked a couple slides back, now we're talking malpractice. This is, I mean, you know, the court said in considering the claims, you know, the claim that the production was completely unusable, this statement is false, not inaccurate, not off topic, not wrong, not misguided or mislaced. False, harsh word, right? And then later on, the discussion about whether the parent-child field discussion, you know, the record, however, belies the contention made by the plaintiff, and the vendors explained the production included fields for the beg baits and end baits, and Baugh's vendor acknowledged that those fields were included in the production. So this wasn't false, but the assertions belied the facts. And then finally, you know, admitting, well, I didn't really use the software. So I'm making statements about the software, but I've never really used it. I mean, I'm thinking Rule 11 here, right? I mean, aren't you signing something that says that everything is accurate to the best of your knowledge, and you're making assertions that are, as the judge said, false. So I don't know. I don't know. This one literally left me like feeling like I did when I watched Aaron Judge drop off fly ball in center field. Oh no! Oh no! Oh no!
Judge
Oh no!
Peck,
Oh no!
Judge Peck is wishing you hadn't gone there, but
well, you know,
yeah, yeah. I mean, it's interesting that she's disagreeing with her own vendor when it's clear she doesn't know what she's talking about, which is kind of. You know, which certainly became evident once they had the hearing. So
yeah, I also, just as an aside, I found it funny that at the end the judge said, "I'm denying their request for a protective order," and her request for sanctions. I'm thinking, wow, given all of that, she was asking for sanctions against the other side.
Right. Exactly.
Clearly at the hearing, Judge Numbers got plaintiff's number and found it inappropriate.
Yes, indeed. Yes. The only judge that not only has his name to numbers, but has a number in his name. So interesting. So Judge Peck, the parties agreed to a joint report which said the production would include metadata, didn't specify the metadata, and that portion of the joint report was adopted as part of the court's case management order. With that being the case, should the court be more proactive to point out shortcomings in the joint report to reduce the potential of discovery disputes downstream?
Well, you know, let's be realistic. In a perfect world, maybe, but most of the time, if the parties submit a stipulation, you know, saying they're going to do X or whatever, or here the 26F report, the court is just, let's be honest, signing off on it. Looking at it, there's nothing horribly wrong in it. Approved, move on. So, no, I think we are seeing in certain instances, the parties bringing non-dispute disputes to the court. Like, we're doing an ESI protocol and want to know what the paragraph on 502 should be. Is it a B or a D? Judge, tell us what to do. That's not really the court's job. And talking to some of the judges from federal courts in Texas, they refuse to even entertain those sort of disputes. And I don't think they're wrong on that. So if the parties said, we're going to produce metadata, and nobody said, but what metadata, that's all the court should likely be doing until there is a dispute.
Yeah, that makes sense. So Mary, both parties had ESI vendors, yet the joint report didn't detail the metadata to be produced. How could this happen?
Well, it could happen in this particular case, which is like a poster child for technical incompetence, unfortunately. It's like we had the begin attach, the end attach, which to somebody who's never seen these metadata fields would mean absolutely nothing. But to somebody who understands productions, they'd be able to, put them into a system. The thing that I found most persuasive was that they didn't have dates. And so there would have been another layer of processing necessary to extract or abstract dates. And it makes me wonder if there isn't a core set of metadata that should accompany productions in addition to extracted text, which makes it reasonably usable. And that would be a date, because you can't do data reduction without that, and you can't do data reduction without a custodian field. So, maybe those two things at least should be included in a metadata specification. But most importantly, I think the attorney needs to either engage somebody or learn about the system before bringing something to court. It's just embarrassing.
Yeah, agreed. And I kind of have a feeling, we don't know the circumstance here, but I kind of have a feeling that maybe the parties agreed to these specifications before they brought vendors in, perhaps. Maybe, because a knowledgeable vendor you would think would have known the things you're pointing out, and certainly say, if you're a requesting party, we got to have those dates in there. We got to have certain standard fields in there. So, we know how it goes all the time. Attorney agrees to something, then a problem comes up, and then it's like, oh, okay, we got to bring our vendor in, when they could have had the vendor in at the beginning, and maybe that might have had a different outcome. So we'll see. Certainly interesting. A question from the audience here quickly. The mention of producing or not producing in native format raises a question of what this particular panel thinks about native productions. He also adds, though, here, even in producing in native format, sounds like boss counsel would know how to do that either. So probably true. But any thoughts about native productions from the panel?
Well, I always, this is Tom, I always would prefer to get native if possible, but these days in the world of litigation databases, an export with a concordance load file and TIFFs and et cetera, is so standard that that's a fight you often don't want to get into. The resolution we often see, that I often get, is, yeah, we'll do that, we'll accept that, as long as you give us a link to the natives if there's an issue, or you'll at the very least agree to provide the natives if we come up with something that we find needs to be looked at. So
certainly, I think you still see most parties seem to agree to a TIFF or PDF type format. But obviously, with exceptions, Excels are, I think, pretty universally produced
Well,
in
yeah.
native these days,
Yeah.
and what have you. But yeah, I mean, I'm certainly a fan of native productions or near native, because some cases you can't produce totally in the native. But you know, I think that we're still finding that battle of getting others to be kind of think of this as data and not documents. That's another soapbox for another time. So,
You know, the other issue, of course, is you mentioned Excel spreadsheets, which, yeah, those are sort of an exception. Big databases, you know, we see some cases where there's big databases, but video and audio, which is becoming more and more widespread, especially in criminal cases. I know I've worked with my old friend Russ Aoki up in Seattle on some cases, and you know, there's just a huge amount of video and audio, so you're going to get those in native. That's just the way it is, and then that doesn't really solve anything. Then it becomes a problem about how do you deal with them, how do you search them, how do you handle them.
Yeah, that's all. There's definitely exceptions and more exceptions to the rule, which is why I think eventually we may see more native productions. Gareth with a comment, concordance. That's so 90s. Yes, indeed. That's we're still basing our production on old formats. But regardless, here's our next treat. A case involving one of our favorite judges, Illinois Magistrate Judge Jeffrey Cole, in a case that was suggested by Alicia Hawley. In this class action, the defendant proposed a list of 29 custodians. After 6 weeks, the plaintiffs made a counterproposal of over double, 60 proposed custodians that included at least 4 in-house attorneys. When the parties met and conferred, the defendant was willing to add 10 of the plaintiff's 31 additional custodians, but didn't like the addition of the 4 attorneys. The plaintiffs didn't want to budge. Ultimately, the defendant offered to agree to 50 custodians if the plaintiffs would simply drop the attorneys. In exchange for keeping the 3 lawyers on the list, plaintiffs offered to drop 3 non-lawyers, keeping the total at 50, but the defendant refused, leading to the motion before the court. Judge Cole began the order with this quote, saying, "The discovery rules are not a ticket to an unlimited, never-ending exploration of every conceivable matter that captures an attorney's interest. Parties are entitled to a reasonable opportunity to investigate the facts and no more." He also stated, among other uncomplimentary descriptions, modern-day discovery has been called a runaway train, a monster on the loose. Well, that's appropriate for Halloween. Call it what you will. The inescapable reality is that discovery has come to dominate civil litigation. Proportionality, like other concepts, is not self-defining. It requires a common sense and experiential assessment. In other words, all are agreed that discovery has gotten out of hand over the years and needs to be reined in, but just because counsel in this case insists that there are 50 or 60 stones to be looked under does not mean they get to look under every one of them. He also added that, first of all, frankly, 50 custodians is not a lot. And he mentions that, you know, so even if plaintiff's motion is denied, which it is, they still pretty much get everything they want in terms of custodians. And that local rule 37.2 is about compromise, and it's the nature of a compromise that neither side gets everything it wants. He also pointed out that you know, the issue of potentially the fact that discovery being sought from several attorneys, it's not naive to think that that wouldn't be time consuming and costly when you're dealing with privilege claims as to documents from the lawyers, which would far exceed privilege claims as to non-attorneys. So he rejected the plaintiff's motion, saying, when the foregoing is weighed on the proportional to the needs of the case scale, the balance tips decidedly over to the disproportionate side. The aphorism, as the book is not worth a candle, is not out of place here. So Judge Peck, Judge Cole made a big deal about the number of custodians, even though this is a class action, which tends to have more expansive discovery. What factors would you consider to decide whether or not too many custodians were being requested?
You know, you can't just say it's a big case, so 40 is the right number. It's a small case, 5 is the right number. Got to know who was communicating with who and how they communicated. You know, in some companies, you know, there is a sort of a departmental mailbox. So everybody who's, in HR sends all their communications by CC or BCC to the departmental mailbox. You want to know how much duplication there is. Did custodian A routinely copy custodians B and C, or employees B and C who somebody wanted to be a custodian, on all of their communications? All of those things are things that the court would need to deal with, and, again, maybe break it down by role in the organization. Sales, how many salespeople do you need to look at? How many people in the accounting department, et cetera, et cetera, et cetera, with the ability to analyze the data from the number of custodians produced for who was communicating with who, and will that, say that there are other key custodians who were not, other key persons who were not custodians who should be added in. There is no way for a court to decide on the number of custodians without all of that sort of information. Otherwise, it's just we know it when we see it sort of thing, or
right.
Yeah, that's too many, cut it down, et cetera. So it's really incumbent on the parties to provide that sort of information. And here, with 50 being apparently a very large number, and it started with half or a third of that and kept building up with the defendant saying, fine, we'll give you more, et cetera. It got to 50, and then, when it came to the lawyers, they just said enough is enough.
Yeah, indeed. Yeah, I think the who knew what when is demonstrating that certainly is key there. So Mary Judge Cole identified the potential for privilege claims from the in-house lawyers as a factor that would drive up the burden of discovery from them. Should that be a factor in deciding whether or not they should be included as custodians?
Well, sure, it's cost, so it should be included, and cost to the producing party for sure, but then also cost to the court, because this quote, this merger was so fishy that plaintiffs are entitled to whatever they desire. Damn the burdens, costs, and judicial resources. So, and there'll be a privilege log for each lawyer. Their files total 442 gigabytes. So anticipating some disputes over in-camera looking at these things, I can see that the judge just did not want that, and then cost certainly is a factor.
Well, that's one way to slow down the runaway train, right? So yeah. So Tom, what if anything could the plaintiffs have done to make a case that those 3 or 4 in-house attorneys should be included as custodians?
Well, first, I just got to quickly mention, to Judge Peck's point, I thought the issue of the numbers counting was kind of crazy. We want 60. Well, we'll give you 40. We'll take 50. We'll go 50, but it's got to be the lawyer. It reminded me of the prayer to the holy hand grenade from Monty Python. The number thou shalt count shall be 3, and the number of the counting shall always be 3. 4 shall not be the number. Neither count to 2, except that they proceed to 3, and 5 is right out. It just got to that point where, okay, the judge must have just gotten sick of this. As to the lawyers themselves, I thought the judge made several statements that were right on. He referred to the unpersuasive arguments regarding the relevance of the discovery from the 3 lawyers, end quote. Much like I said at the onset with our first case, you got to bring something to the table that the judge can look at and say, okay, here's a reason for me to latch on to that you're going to want these, other than you're just throwing 3 more names in the hat. And I think also the judge said, quote, significantly, plaintiffs say nothing in their motion about how any of the 50 particular custodians, more importantly, the 3 lawyers, are proportional to the needs of this case, end quote. So I thought the judge thought that not only were they getting too much into the counting, but there was a lack of explanation for how any of it was proportional, as he said several times. This is a lot of people here. This is a big number.
Mm-hmm. Yeah, certainly is, and certainly very interesting. Kind of, custodian disputes, I think, are always interesting to determine that. By the way, Mary Pat threw in a question: whatever happened to a phased and deliberate approach? Which is certainly fair. And here's something scary.
Whoever did that.
Right, I know, right? But here's something scary. We are at time and we still have a case to cover. So we're going to try to blow through this last one as quickly as we can. And my apologies for not doing it full justice. I'm going to very briefly try to set the stage here, which basically this is a case, again, suggested by Judge Peck, also covered by Michael Berman on the EDRM blog, involving claims of sexual harassment. And EEOC accused the defendant of failing to preserve emails, laptops, and cellular phone data for custodians, including the two plaintiff supervisors. Basically, as it turned out, the defendant didn't have a policy to preserve phones and laptops, though they indicated that the laptops were being backed up to the cloud, so that made them irrelevant. They also claimed there was a backup system failure resulting in the loss of the two supervisors' emails, but as it turned out, not so much of anybody else's, which was interesting. One of the things that ultimately came down to is when they had a duty to preserve, of course, which was no later than September 7, 2018. Judge Ivey noted that the defendant cannot explain why Thompson's and Littleton's emails were lost during a shift in cloud storage, while other email accounts were preserved. It's understandable that the EEOC is suspicious of the loss of the two most key persons in plaintiff's claims. And certainly pointed out the fact that the defendant had a lack of policy to even preserve cellular telephone data, which he said does not absolve it of responsibility to preserve ESI under the federal rules. So, finding prejudice, he basically ordered the defendant to produce the litigation hold notice. The date notice was sent to employees and other information about that. He also addressed other issues, including the defendant's self-collection of ESI, stating counsel cannot merely rely on custodians to self-collect ESI. So that's the very quick reading of that case, which of course you all can see on the slide there. Mary Judge Ivey called out counsel, speaking of self-collection, regarding the defendant's self-collection of ESI. So what recommendations do you have for our audience on how counsel should manage or supervise the collection of ESI? And Mary, you might be on mute again. I don't know.
That is very scary that I am on mute again. Thank you. Thank you. Yeah, so you have to know your case, and is it one that would lend itself to custodian self-collecting? For example, if you had fraud in the IT department, you probably wouldn't want the IT department collecting data. And an EEOC complaint about a specific individual, you might not want them doing the collection either, but also just having some instructions on how to do it, not just dragging and dropping it, changing dates, and then overseeing the accuracy, like, the reasonable inquiry type of standard. Make sure that you look at the whole, at least for a sample, of custodians, and make sure they understand your instructions and are pulling the right files.
Yeah, absolutely. All great points and great suggestions, recommendations for managing your client's collection effectively. So Tom, what do you think about the fact that Thompson's and Littleton's emails were lost during a shift in cloud storage while other email accounts were preserved?
Well, highly irregular. I mean, I'll just repeat what the court said. The court said the defendant never explained why just those two were missing. while all the other email accounts were preserved. And then, quote, it's understandable that the EEOC is suspicious of the loss of the two most key persons in plaintiff's claims, end quote. Suspicious would be the word.
Indeed. Yes, I can understand that suspicion. So, Judge Peck, shouldn't the failure to even have a policy of preserving employees' telephones and laptops be considered intent to deprive the opposing party of that evidence?
No. We've gone from the older residential funding standard on spoliation to the new, very clear intent to deprive specific to the opposing party in the case. A policy, general policy or not, doesn't go to that. Now, one could easily here have found, based on what you were just talking with Tom about, that the mysterious, spooky destruction of those two employees' files while transferring to the cloud, that could be circumstantial evidence from which the court could find an intent to deprive. But policy or not, obviously much better to have a policy, but its presence or absence doesn't go to intent to deprive, in my view.
Right.
Okay, fair enough. And certainly, given that they've gotten approval to get the litigation hold notices, I would expect to hear more on this case, which could eventually lead to some sanctions requests. So we shall see. In the meantime, here's the contacts page, and you can be thankful that our next case law webinar is only 3 weeks away, where we'll serve up 6 new tasty case law rulings. So with that, I will hurriedly say thanks to Mary, Tom, and Judge Peck for all their terrific insights as always, and I'll turn it back over to you, Mary.
And we thank you too, Doug, for anchoring, and Tom O'Connor and the Honorable Judge Peck for this insightful presentation. Our thanks to the EDRM community for your kind attention. If you really loved it, show the Honorable Judge Andrew Peck, Tom O, and Doug Austin from Houston some love. Find your emojis at the bottom of your console. And to be automatically registered for on-demand webinars, click the pop-up at the conclusion. Once there, click the bell to subscribe for updates. And we'll see you next time on the EDRM Global Webinar channel. Thank you.
Happy Halloween, everybody.
Happy Halloween.
There we are.